what Betsy DeVos has to say to these Americans is basically, too bad, your future will need to wait while I figure this out. She spoke over and over again about protecting taxpayer dollars. I mean, we're all members of Congress. We too want to protect taxpayer dollars. But I think the difference is that we want to protect taxpayer dollars from going to these fraudulent schools. We want to protect students from the pain and the agony of having to have that bright future, that bright promise deflated, but more importantly, then have to climb out of the mountain of debt that you're under. You know, these are schools that have pocketed billions of taxpayer dollars, and it's us who foot the bill. It's us who foot the bill for them to continue this cycle. And this hearing was an important step on shining the light on the damage that Betsy DeVos's Department of Education is doing to our country's students. But we're not stopping here. We need to overturn the 2019 borrower defense rule that weakens oversight of predatory for-profit schools, rules that make it hard to predict when schools are about to go under, rules that make it even harder or even impossible for defrauded students to seek loan forgiven after they've been defrauded. I introduced a resolution in the House along with Senator Durbin in the Senate to overturn this harmful borrower defense rule. And I'm proud to have the support of my colleagues in the Education and Labor Committee, and I am confident that Congress will see the facts and lend their support too. It's time for us to hold Betsy DeVos accountable to students in this country. Thank you.
I'm Congressman Mark Takano, and I come from California's 41st District. I was a former public school teacher for 24 years and a community college trustee for more than 2 decades. I consider myself a teacher on special assignment to Congress. I remember in my final years of teaching, hearing that students were not going to the community college where they could, and many of them were struggling, and they needed some time to bring up their skills, but they were being very aggressively recruited by for-profit institutions and being made to put into debt into programs that weren't going to lead anywhere. This really made me angry in the wake of the 2008 recession that we had in California, that families that were being put out of their homes now were having their kids, and actually moms and dads that wanted to retrain. The companies that had money at that time were the for-profit schools that could afford the big billboards advertising to them. Now, I was frustrated with Secretary DeVos's testimony today. She said several times that the reason why Corinthian students, borrowers who were Corinthian students who had been defrauded, why they had been collected upon, why loan payments were still being collected by loan processors, were because of processing errors. I tried to ask her, why did it take 18 months for her department to hold its first in-person meetings with the executives of these loan processors to clarify how to comply with the federal court order that existed 18 months before? She really couldn't answer that question. What the court had found was that the department had only sent actually 1 or 2 emails, that had only been email communication. She said, well, no, that wasn't the only thing, but that's what the court had found in October, and that's part of the basis and actually the department itself. I read to Secretary DeVos a quotation from her department's own submission to the court, to Judge Sally Kim, that the department basically conceded. They were saying that they weren't guilty of willfulness in defiance of the court order, that it was gross negligence. So yes, Betsy DeVos is the denier in chief. She is denying any responsibility for anything. She is the neglector in chief. Her department is guilty of gross negligence. And what is that gross negligence? By not having meetings with these executives of loan processors, by only giving them 1 or 2 emails directing them to stop collecting loan payments from these students. What resulted was 18 months later, 45 borrowers were illegally collected upon in defiance of that court order. This is mind-boggling. And we don't know whether there are more borrowers out there that are being collected upon in this class. This is a direct result of the incompetent management of the Department of Education and the Secretary's gross negligence. Student borrowers were defrauded by predatory schools are suffering. They're facing financial and emotional difficulties as a result of the Secretary's inability to work on their behalf. Many have had their wages and tax returns garnished, and some have suffered negative impacts on their credit history. Let me be clear. Our students deserve better than the treatment they're getting from Secretary DeVos. These defrauded borrowers, student borrowers, deserve to be made whole. They're whole. They are entitled to it by law. We will not stop holding the Secretary accountable until each and one of these claims is properly processed, as is required by law. We will not let her get away with her scheme that will shortchange more than 200,000 borrowers currently waiting for relief and deny them justice that they so desperately need. Thank you.
Thank you. What's going on? Thank you very much. I was not frustrated today. I was just angry. Angry that 3 years into her term as secretary, the secretary still cannot give us clear answers and can still not manage her department. There is no excuse to have 200,000 borrowers who have not been properly processed. And the answer she gave us was literally a lie. She has not hired enough people to process these 200,000 plus borrowers. They have not staffed up. And the numbers they gave us are literally impossible. They suggest that an individual lawyer could process 300 individuals a day under their standards. That's impossible. The VA can't do it, Social Security can't do it, and they have thousands of employees. She is not only the denier-in-chief, she's clearly incompetent. And 3 years into it, she's still blaming her predecessors. And that also is actually unprofessional. In 8 years, testifying all the time, I never issued a press release complaining about my predecessors. I never publicly, because I had a sign on my desk that said the buck stops here. The buck stops with the secretary, and she clearly is not doing her job. Thank you.
Thank you. And as I said, the 4 congresspeople have to rush off to votes on prescription drugs or on trying to lower the cost of prescription drugs. So I just, for the record, want to make sure that we really thank them and grateful that they're now going to rush and run to do their votes. I want to introduce the 3 of the people who have been directly hurt by this kind of action by Betsy DeVos. You heard the frustration of the congresspeople trying to get answers. When you have someone who has huge responsibility to make sure that the various different student loan programs that the President of the United States, former presidents, and the Congress of the United States have approved on a bipartisan basis from back to the GI Bill in the aftermath of World War II. Told Betsy DeVos, there was no question about this basic social contract that in exchange for us seeking and asking our young adults to actually gain the knowledge and skills they need in America to have a post-secondary education, that those who could least afford it would actually be able to have the costs of college or other post-secondary education defrayed by the government of the United States of America. This basic bargain that in exchange for going to post-secondary schooling which was not paid by the taxpayers, but was paid by private funds. That in exchange for that, when President Bush and President Obama and President Clinton and the other President Bush, even President Nixon, all got onto podiums saying it's really important to go to college, that if people couldn't afford it, or there were issues around that affordability, the federal government would step in. That's the process that Betsy DeVos inherited. That's the paradigm that Betsy DeVos inherited. And what you see today in her testimony is her true colors, her ideology coming through. Because what she does and what she has done, whether it is the borrower defense rule, whether it is veterans, whether it is supporting for-profit colleges that have fleeced kids instead of supporting those kids, whether it is the denying of public service loan forgiveness, in each of these really important measures that have been done on a bipartisan basis for this social contract of in exchange for going to college, if you can't afford it, the federal government will step in. She demonstrated today not only her sneering at that concept, she demonstrated how her department will refuse to actually do what they are legally required. I don't know if it's negligence, if it's incompetence, or if it's malfeasance. What I do know is that it is a pattern and practice of pauperizing a generation of students who have gone to college and need to have the promises that we have made to them to forgive or defray their debt, to make those promises real. That's why we call her the denier-in-chief, and that's why this administration must be held to account for turning their back on students who are going to college. And so with that, I want to just actually introduce Kishana Mahoney, right? Mahone, did I say it right? Mahone. Kishana Mahone from Illinois, Gloria Evans from Missouri, and Matthew Cortland from Massachusetts. They all have a really poignant story to tell, and I want them instead of me to tell it. Let's start with Keisha.
Good afternoon. Again, my name is Kishana Mahone. I attended Illinois Institute of Art in Chicago, a for-profit college. I just want to share my story. I started school in 2017. I am okay. I want to take my time because I do want to represent my classmates and others who are not able to be here. I want to represent it, and I want to let you know how real this is. Every time I speak of it, I get a little bit choked up, simply because I am a single mom. I raised my son. He had a dream of being a singer, so I dedicated my life to helping him. So I set my dreams on the back burner. My son became an adult, and after chasing his dreams and accomplishing some things, I picked my dreams back up, and I started looking for schools. I found the Illinois Institute of Art because they had a major in design and graphic design, which that's something I wanted to do. I was promised that if I come to school, if I apply myself and do what I needed to do, that I would leave that school with a bachelor's degree, and go on to further my career in graphics design. I did my part. I went to school, I applied myself, I sacrificed, I committed. I stand here today with no bachelor's degree, but I have debt. Debt that I was told doesn't mean anything to them. I was denied the closed school discharge. I was denied to have my loans relieved. We weren't known. I went to the school, and in 2018, June of 2018, we went on break. And no one knew anything. Then we were sent this an email saying that they were not going to accept any more students. They closed the enrollment. We still didn't know what happened. We didn't know. We went back to school in July, and we finally was told that the school was going to be closed, just like that. There was no mention, and further we found out later that the school had lost its accreditation in January of 2018. It is now July of 2018, which means in January of 2018, they lost the accreditation, but no one was told. They took away our decision. We didn't have a choice. If they had told us in January of 2018 that they were closing and that they had lost their accreditation, we would have had a choice as students to leave the school and make other decisions. But the decision was made for us. We felt that we were defrauded, not only by the school, but the Department of Education as well. Because once they lost their accreditation, well, we shouldn't have been responsible for the debt that was incurred, it continued to incur. So we lost our choice. I want you all to understand that this is real. And I know a lot of people don't understand that this is real. They changed our lives. They destroyed us. And now I'm sitting here a year later, not knowing what to do, not knowing how to pick up and go. My credits were not taken from other colleges. So I'm sitting here not knowing what school to go to because no one would accept my credits. So I spent a lot of my time, dedicating to school, and I'm standing here a year later with no degree. So my classmates were devastated, and so was I. So it wasn't until we sued, Senator Dick Durbin took our case and made it bigger. He helped us, and we have a team of attorneys that made the Department of Education take some type of responsibility, because the responsibility was left upon us. I just want you all to know that it changes lives, and we were devastated. You're welcome.
This group of advocates are gonna fight and fight and fight to make you right. Thank you. Gloria.
Hello, everyone. My name is Gloria Evans Nolan from St. Louis, Missouri. And I am one of the plaintiffs in the Weingarten versus DeVos in the Department of Education case surrounding public service student loan forgiveness. As a child, I had a pretty rough upbringing. I had a mother that was incarcerated. I didn't know who my father was. And because of my mom's incarceration, after a few years of living with my grandmother, my brother and I landed in the foster care system. So without that strong foundation, I was misguided a bit. But I happened upon some educators that really believed in me and told me that I was great and that I was going places. And those educators, along with everyone else around me, including all of the messages that I received, told me that getting an education would be my way out of poverty, would be my ticket to the American dream. And so I pursued that. Without parental help and family support, I turned to some student loans and some grants to take care of my education. I left college with a master's degree in 2005. At that time, I had $62,000 worth of student loan debt. Today, I still owe $58,000 in student loan debt. I have been paying the entire time. In 2007, a program was introduced stating that people like me who worked in the public sector, who worked in nonprofits or teachers or other professions serving the community could have their loans forgiven after paying 10 years. I had already chosen my career, so I wasn't going after a certain career based on this forgiveness, but it would have been icing on the cake for me, and I was already working towards it, so I felt like this is a great opportunity. At that time, I called my then loan servicer to inquire about the program, and I was told by the person on the other end, you need to make 120 payments, so we shouldn't even be having this conversation. And so with that person being the one with the information that I should pay attention to, I thought, well, okay, I'm gonna follow this guidance that I've been given and continue making my payments. I later learned that I was on the wrong payment plan and had been for 6 years, and so those payments wouldn't be counted. And so what I did was, of course, I'm a little feisty, so I tried to state my case. And after listening to the hearing a little bit today, I realized that there must be some playbook, because there was a lot of denying, a lot of buck passing, a lot of, this isn't my fault, I don't know, we're just going through the process. So I heard that today in the hearing from Secretary DeVos, and I heard that on the phone from the loan service the loan service providers, and it's also unfortunate. I did, however, finally enroll in the correct payment plan and started to make those payments starting all over again. And after doing so, a new program was introduced, the temporary expanded, because like me, a lot of other students, graduates had experienced the same things, and we couldn't have all been crazy, right? So they expanded the program to cover some of those payment plans that weren't originally covered. When I went to apply for that forgiveness under the new program, I was denied. Denier in chief, right? It's been a very tedious process, but I told you I was feisty, and I continue to push, continue to try to seek the necessary answers, and I wound up being blessed to find Randi Weingarten and the AFT. I joined, I'm proud. I think that it is a blessing for unions to still be around and represent the people, because obviously we're not being thought of very, very highly by the offices that should think of us highly and deliver on those promises to us. So I am proud to be working with this case and get justice. And it's not just me. There's thousands upon thousands still talking to and trying to seek that right information and being denied over and over again. And we all can't be crazy, right? And I really, truly believe that it is a new day, and it's been long overdue. Thank you.
Hi, my name is Matthew Cortland. First, thank you, President Weingarten and AFT, for leading the fight in this area for student loan justice and fairness. I think one of the only things this administration understands is litigation, and sometimes court orders, although with Secretary DeVos, that's a bit iffy. We heard this morning that Secretary DeVos is perfectly happy to use data from the Social Security Administration as an excuse to avoid making borrowers who were defrauded whole. But Secretary DeVos is unwilling to use that very data, the same data from that very same agency, to discharge the student loans of disabled borrowers. There are some 200,000 people who have been found by the Social Security Administration to be disabled. And it's really important that we're clear that the Social Security Administration's disability determination progress is extremely rigorous. What do I mean? Between 2013 and 2015, fewer than 35% of disability applications were ultimately approved by the Social Security Administration. Some of those were approved only after the claimant got before an administrative law judge, lawyered up, went through the whole process, waited years. And instead of using the outcome of that process, instead of using the Social Security Administration's data of who disabled borrowers are and discharging those loans on what the Department of Education calls the basis of total and permanent disability, Secretary DeVos wants to make those disabled borrowers jump through even more bureaucratic hoops. The department sent out its own disability discharge application to those borrowers it knows to be disabled. And proving a disability to the Department of Education using its own form is not easy. I know, as a disabled borrower, I've done it myself. It was confusing and burdensome, and I was ultimately only able to navigate that process because I'm a healthcare lawyer. And at the same time, I had access to healthcare. One or the other wouldn't have been enough. I needed clinicians who would be willing to jump through the bureaucratic hoops, fill out the Department of Ed's paperwork. Luckily, some of the leading experts in the treatment of Crohn's, a kind of inflammatory bowel disease, are willing to take care of me. And I was extremely lucky to have a gastroenterologist who was willing to do the very real work, not just of quite literally keeping me alive, which is sometimes not easy, but also completing the disability discharge application from the Department of Education. We should not burden people who have already been found to be disabled by the Social Security Administration with the additional work of filling out paperwork for the denier-in-chief. We should not do it. We also shouldn't burden clinicians. At a time when our healthcare system is stretched so thin we are almost at the breaking point, to require the time of my gastroenterologist to fill out more paperwork when she's one of the world's leading experts on Crohn's and inflammatory bowel disease, she should be saving people's lives. She shouldn't be filling out forms for Betsy DeVos when the secretary already has the information that she needs. In short, you shouldn't need to be a lawyer to obtain borrower defense relief or public service loan forgiveness or a discharge on the basis of disability. But that's ultimately what we've come to. And that's why I'm so grateful for you all for leading the litigation efforts, because ultimately that's our best chance. Thank you.
Thank you, Matthew. So that's why in the aftermath of this hearing today, we've brought together a few of the, frankly, hundreds of thousands of students, millions of young people and not so young people who've actually gotten hurt because they went for their aspiration, for the promises, for the declarations that America has made on a bipartisan basis to go to college, to get your degree. And this, frankly, is the first Secretary of Education in a Republican or Democratic administration that seems more focused on helping her buddies, her friends, the profiteers, the loan servicers, than on helping students. Frankly, I'm not sure whether it's incompetence, negligence, malfeasance, or willfulness. When you deny borrowers who have been defrauded by for-profit schools, like Kishana just talked about, when you deny borrowers who have been harmed by loan servicers, as we've heard over and over again, Fedloan, Navient, the stories are legion. When you deny borrowers who are veterans with disabilities, even despite an executive order by her boss, when you deny permanently disabled borrowers, like Matt just talked about, even though it is clear as day from Social Security what their status is, and when you deny the millions of teachers, nurses, and firefighters, like Gloria, who were told by President Bush and and Senators Clinton and Kennedy and others, that if you work for 10 years in the public sector as a teacher, a firefighter, or nurse, and you pay your loans for those 10 years, the rest of it will get forgiven. There's a pattern here. That's why we call her the denier-in-chief. There's a pattern of hurting students who have done everything the right way, harming them, pauperizing them. When you are the Secretary of Education, who should be doing everything to help them, to cut bureaucracy, to cut paperwork. Betsy DeVos's job is to help students. That's the oath of office that she has sworn, that she took. Her performance today and the operation of the Department of Education with regard to student debt shows she does anything but. That is wrong. That is why we will advocate against what she's doing. That is why we will litigate against what she is doing. And that is why we'll do everything in our power to get her out of that office. It's time for her to stop harming children and young adults. And if she can't do it, we need somebody else who can. Thank you. Questions? Yes. We are looking at that now. We already are in the midst of litigating on PSLF. That's the Weingarten versus DeVos case. We are already litigating against Navient. 21 attorney generals are now supporting us in the PSLF litigation. We are looking at other litigation with some of our allies and friends that are here. But we are going to look at that formula. We were as surprised as others when patriots in the Department of Education said that she moved forward on this over the objection of those people who have spent their careers helping kids and helping young adults, because it did feel like a bait and switch here, that as she was saying this is about helping those young adults and not so young adults that were fleeced by these for-profits. She's actually, at the same time, shortchanging them. So we're going to look at that. Now, basically, by taking all this litigation, as Matthew said, we're frankly doing the work of what these public servants should be doing, or so-called public servants should be doing. But we're going to look at that now. Anybody else? Thanks very much. And I want to just say to all three of you, thank you. And, you know, this is what it means to have a labor union having your back. We are going to keep fighting until you get justice. And then we'll fight some more. Thank you.